matter of Coupland Cavendish Limited and Finance.
Good morning.
Good morning, Ms Bedford. As you see, we're sitting with Costs Judge Whalan today.
Yes, good morning, Master. May it please the court, I appear this morning together with Mr Mason for the appellant, the former solicitors of the respondent's client, Mr Turner, who is represented by Mr Dunn and Ms Coupland.
Yes.
As the court will be aware, this is my client's appeal against the decision of Mr Justice Sweeting.
We can tell you that we've read the Costs Judge Rowley's judgment, we've read the judge's judgment, we've read the skeleton arguments, so we know what the case is about.
Thank you, my lord. I'm grateful for that indication. Perhaps then if I can move through quite quickly. The question, of course, is primarily a question of the Costs Judge's initial case management decision. That has a simple hue of a case management decision and a discretionary application thereafter. But the decision is underpinned by 4 antecedent questions, those being the matters upon which my Lord Justice Lewison gave permission to appeal, that being the role and function of the cash account in a solicitor assessment, the extent of any ability to interrogate the cash account, the impact of any fiduciary duties, and the threshold questions. I shan't take you through the case.
It seems to us, if I may say so, that the important point in the case is the cash account.
Well, my lord, that's exactly what I was going to come on to. Whilst we have those matters, if I can approach it in this way, first of all, I think I do need to deal with an ancillary point as to whether the interpretation of Section 70 is a new point or not, and that being an issue raised against me in the respondent skeleton. Once we've dealt with that, the primary issue in my submission is exactly as identified. It is a question of the role and function of the cash account. Once that has been dissolved, it's going to frame up whether there is an issue in dispute within the assessment, to which one can then apply the Part 18 threshold. There is the issue as well, of course, of the case management. It is a part of this appeal, but it's probably a short point and I can deal with it hopefully very swiftly at the end. If I can possibly just have a moment just to give a bit of context to the background. I'm aware that this panel is strong in the matters of Solicitor Act matters, and that there's been a number of decisions awarded or handed down by your lordships and your ladyship on that. But the statutory framework with which we're concerned is of course contained in Section 70. And I say, for points that I'm going to come on and make good, that framework is a complete code insofar as it deals with a client's rights to assessment. This of course is within tab 1 of the bundle, of the authorities bundle. I'll come on to it momentarily. What I do say is that it creates a complete cradle to grave process. And the duty to certify the amount of the cash account sits within that context, and in particular within subsection 7, with which this court is concerned.
Where do you get that from?
Pardon?
Where do you get that from?
Subsection 7 of the...
What subsection 7 requires the Costs Judge to certify is the amount due to the solicitor in respect of the bill.
Absolutely. The cash account comes in and is referenced in part 46 of the CPR in respect of 6.119 subsection B. That is a document that has to be filed and served with the breakdown. And in my submission, what that is intended to do is give effect to the duty to certify under subsection 7, and is the practical way that the court can, in terms, understand what is being paid on account to the solicitor during the course of the claim. And for reasons that I'll make good in my submission, subsection 7 is just concerned with understanding what in fact has been paid on account, so that the Costs Judge can then certify what further sums are due to the solicitor in respect of the bill, or whether a refund needs to be made to the client going the other way, again, once one has worked out what is the assessed amount. So that is the context of, in my submission, the importance. Perhaps if I can work forward from the new point on the appeal and address that before the question of the application of the cash account. This may be a point that is not intended to trouble the court too much, but the point is raised that it's a new point. In my submission, the duty to certify was a feature in the skeleton argument before the cost judge. You'll find this at page 169 of the supplementary bundle. You'll see it right at the end, the italicised paragraph. Under the heading is the cash account, the matter in dispute in these proceedings. It's under footnote 9. I'll leave the court to read that for a moment. Thank you. This is important because the Part 18 questions were put in 2022, a substantial time period before the actual assessment hearing itself. They don't seem to have troubled anybody in the interim period. It was a matter only raised more formally within this skeleton argument that was filed before this detailed assessment hearing, a matter of 3 days before. So the point in the case management was that there was never any application. So it was rather unclear to a degree the issues that were going to be traversed. The argument then appears to have been expanded somewhat in oral submissions. And you can see this, that the claimant advocate filed lengthy further submissions on the point in relation to the court asking for assistance on what certify meant. And that is at page 179 of your supplementary bundle. There you'll find an email from Mr. Carlisle after the hearing, the 4:37 on the 14th of September. You'll see under point 2 that's enumerated the issue of the certification points within an attached supplemental skeleton argument on Rubenheimer.
Sorry, where are you reading from?
Under number 2, in numerate 2, my lady. I
Yes.
attached a supplementary skeleton,
On Rubenheimer, yeah.
and it's the last sentence there. You can see referencing the certification points. And that skeleton appears at 183.
So is the position that the cost judge, when he was dealing with this, didn't have a formal application before him under Part 18, but it developed informally through the skeleton?
That's exactly what happened, my lady, yes. And then also expanded during the course of submissions, which then resulted in that email. And
That probably explains why the request wasn't before him.
that's exactly the point, my lady, yes. And of course, this rather informal way of proceeding in my submission is not actually in line with the practice direction to Part 18 and compliance with putting the application on a proper footing. But nonetheless, I don't think I can go behind the fact that the court does have a general case management power to deal with matters more informally, but it just does underline the difficulty which one gets into when matters are not properly footed.
Just going on with this document, this is Mr. Carlisle's, Mr. Dunn's
Yes, so that's the
skeleton, and paragraph 12
Yes.
seems to summarise the solicitor's argument in that case, namely, which included the scope of the proceedings don't enable the court to scrutinise the cash account beyond the limited arithmetical rate.
Absolutely, which is exactly this point in this appeal today. Then just to finish the points in totality, if I can take you back please to 174. This is the cost judge's comments.
174.
Yes, please, of the supplementary bundle. he says, thank you for your lengthy submissions. They're not what I expected. If I need anything else, I'll ask for it.
Yeah.
But he dealt with a point in respect of certification. In particular, if I can take you to 176, the very bottom of that page, the final paragraph, where in particular he was directing towards a dictionary definition of the word to certify or certification. So in my submission, the point was properly put. This is not a new argument. It has been a developed argument such that there has now been authority from the 19th century which has been turned up in the case of both Cooper and Hewitt and James and Jones, which gives an understanding as to what certification in my submission means and how one deals with a cash account. But this is certainly not a new point. The essence is there. But any event, if the court is against me on that, in my submission, the matters outlined of principle in Singh and Das are more than comfortably satisfied. This is a point of law. The respondent has had significant notice of the same, at least since last July. And in my submission, there is no prejudice. It is a facet of the question upon which my Lord granted permission to appeal. No detriment has been suffered. And so for all these reasons, in my submission, I would invite this court to deal with the point.
Right, well, we'll consider that when we deliver judgment.
I'm grateful, my Lord, thank you. Turning now, if I may, to the actual substance and meat of this appeal. The function and purpose of the cash account is that primary question, and in particular, whether it can be adjusted in the way suggested by the respondent within the framework of Section 70 of the Solicitors Act, and if so, in what circumstances, and if so, what in fact can be done and what can be prescribed. The claimant says, and this is the respondent's case at paragraph 69 of their skeleton, that the cost judge has a general power to adjust the cash account to reflect, if proven, secret commissions, that this power sits within a more wider obligation on the cost duty to certify. In my submission, for the reasons I'll make good, that is simply a principle which is not supported by law at all. The solicitor's case is that the cost judge's power within the framework of Section 70 is confined and defined, and it is limited. And as a matter of interpretation and also as a matter of binding authority, that supports the solicitor's case, that the duty is simply to certify the sums due, having worked out what has been paid on account. And that this is for 5 interconnected reasons. Firstly,
You have to slow down because some of us are trying to take a note.
Sorry, my lady. Firstly, the ATE premium is not in fact a solicitor's disbursement, which falls within the confines of an assessment in any event. It is in fact what is termed a non-litigation expense within the binding authority of Herbert and Hampson Hughes. And as such, it falls outside the scope of a Section 70 assessment. Because subsection 7 sits within the Section 70, in my submission it must follow that if the duty to certify is within the framework and the AT premium falls outside the framework, it can't be brought back in under subsection 7 in the way that the claimant is trying to do.
Well, that's partly why I questioned your reliance on subsection 7 as requiring certification of the cash account. Because the cash account, as I understand it, is defined by the PD
Yes.
as excluding anything in the bill.
Yes, but it is in relation to obtaining, in my submission, information as to what has been paid on account
Certainly.
towards the bill.
And
So-
that process, again, according to the PD, takes place after the hearing of the assessment hearing.
Which again fits nicely in my submission and sits within the understanding of the duty to certify what is due after the assessment. So in that respect, there is connectivity and consistency in my submission between Practice Direction 6.19 and also the duty under subsection 7, that they fit together. Because of course, what one has is the framework jurisdiction in Section 70, and then the procedural requirements to enact and undertake the duty under these framework provisions within delegated to the practice direction. Secondly, that the usual canons of statutory interpretation apply to both the Solicitors Act and also the practice direction, such that they must be interpreted by reference to the language, the context and the purpose, and that these considerations do not support, in my submission, a wider duty of the cost judge to certify as accurate every single item that appears in the cash account. The duty instead is to certify what is owing on the bill, and thereafter, as a function of that, determine the cash account. And that process is allowed to take place, as I've said, under Practice Direction 6.19. Though consequently, the court has to consider and use the cash account to identify the payments on account which are referable to the bill as assessed, in order to see what is further owing to or from the solicitor. If payments towards the bill are missing, and the client can prove that they are missing, then the cost judge can adjust the cash account to take into account that additional missing payment on account. What the practice direction and subsection 7 do not do is give an express power to go any further than simply certifying the sum due. Thirdly, that the old authorities from the 19th century, in my submission, in respect of the function and role of the cash account and where the burden lies on which party, remain relevant, all of which support the solicitor's position. Fourthly, that the case of Mr. Justice Ritchie in Edwards and Slater and Gordon does not alter this position, because for two reasons: the question of the role and function of the cash account were not directly addressed in the same way as they are addressed within the context of this appeal, and importantly, including that the authorities referred to this court were not before Mr. Justice Ritchie. I say that that is a principal reason for not following and distinguishing, not in any event that, of course, Mr. Justice Ritchie's decision is binding on this court. And then fifthly...
Well, is that really satisfactory, distinguishing it? I mean, you have to say it's wrong, don't you? If we're deciding a point of principle, well, we're not bound by what Mr. Justice Ritchie decided.
Absolutely, my lord. And I do have to go as far to say that he was wrong, and in fact I do that, because where he concludes that the senior cost judge was wrong to consider the cash account as a function of mainly an arithmetical exercise, he was wrong to do so. The reason being is that Jones and James stands as binding authority against that proposition. So that is why one of the reasons I say the case is distinguishable, because these arguments simply weren't put before Mr. Justice Ritchie. And then finally, in any event, that the reduction to the AT premium as suggested involves disputes as to breach of fiduciary duties, and as per the claimant's submission at first instance, breaches of the Financial Services and Markets Act. And again, there's one authority which is binding on this court which operates against that logic, which is Re Macy and Carey, as applied in the decision of Mr. Justice Johnson in Lisa Jones and Richard Slade. That being the conclusion that there are outer limits to the framework of Section 70, that those outer limits exclude any matters of fiduciary duty breaches and cases of professional negligence. And as a consequence, in my submission, I do invite you to adopt the reasoning adopted by Mr. Justice Johnson in Lisa Jones. If you accept all of those propositions, my lord, in my submission, the position will be this: that there is simply no freestanding right within the assessment for the cost judge to adjust the cash account in the way suggested, whether independently as a standalone procedure or as a function of the assessment itself, and that the authority support the solicitor's position that the cash account is mainly the function of the duty to certify that being simply to show what has been paid on account or not. If I can deal firstly with the issue of non-litigation expense. This is the case of Herbert versus Hampton Hughes from this court, the decision of Lord Justice Etherton, MR, which you'll find at tab 26 of the authorities bundle at page 387. Just briefly cantering through the facts applicable to Hampton Hughes and Herbert. That also arose from a low value RTA claim in respect of which Mrs. Herbert instructed Hampton Hughes to act on her behalf. She entered into a CFA that provided for charges including a 100% success fee, but she also incepted an ATE policy of insurance against adverse cost risk with an insurance company for the sum of 349. 2 bills were thereafter delivered, none of which included the ATE premium, that being in my submission a litigation expense, but the Mrs. Herbert then objected to the amount of being too high in respect to the success fee. She also objected to the quantum of the ATE premium. The first instance decision was before Mr. Justice Bellamy. You'll find those set out at paragraphs 25 to 26, which are page 404.
Mr. Justice Sewell, wasn't it?
On appeal, first appeal from District Judge Bellamy.
District Judge.
District Judge Bellamy was at the instance judge, and he said that the ATE premium was a disbursement. It shouldn't have been in the cash account, and therefore, as we see from paragraph 26, he increased the balance on the cash account by £349, which was the ATE premium.
Absolutely.
And that was upheld by Mr. Justice Sewell. What this court decided was that effectively the ATE premium was properly in the cash account, wasn't a disbursement, and therefore there shouldn't have been the adjustment. But what they left open was ground 4,
Yes.
which we can see on paragraph 32, which was whether there was a PD 46 permitted a merits-based review of the cash account. And that really is the ground of appeal that we are having to decide.
It is, my lord, absolutely. It was the point I was going to bring you to. Thank you for moving me to it more swiftly, because that ties in then to paragraph 72, which was the conclusion. And the conclusion was because there had been a decision that the ATE premium was not a solicitor's disbursement, it was thereafter not necessary to address paragraph 4. So in my submission, what that directs to, and I don't say it's determinative, but I say that it is perhaps instructive, that the question of the ATE premium falling outside the entire scope of section 70 means that it can't then be brought back in under subsection 7. And support for that is the fact that my Lord Justice Etherton decided he didn't need to decide the point. The second point is concern is, of course, the reliance on re-remnant, but my lord, I shan't take you through that. If I can take you then through to the correct approach to the interpretation of the duty to certify. The historical background to the statutory scheme is set out within Menzies, the Supreme Court's decision of Menzies and Oakwood, which you'll find behind tab 37 of your authorities bundle. Before I take you through that, perhaps if I can take you immediately to paragraph 80, which you'll find at page 642. It's the final sentence there. well, two functions actually, forgive me, of paragraph 8. First of all, that the language in the Solicitors Act has remained unchanged for 180 years. So as a consequence of that, the 19th century's authorities, which I have cited in this appeal, remain relevant. It's not simply a case that one can disregard those or distinguish them to the significant extent on the principles. One then goes back, if I may, to paragraph 1 onwards from page 630. There's a short summary of the statutory scheme in paragraph 2. In paragraph 1, it confirms that the assessment of the court is a determination of what costs are reasonably incurred or reasonable in amount. That being set out within part 46, subsection 9 of the Civil Procedure Rules, being the practical procedural code. The statutory framework then moves on at page 633 from paragraph 25 onwards. I flag it simply as a matter of the statutory framework in the event that the court wishes to go through that in the judgment. Then if I can take you please to page 634 and paragraph 34. This is confirmation, if it is needed, that the normal canons of statutory construction are relevant. And the citation is RO, Secretary of State. That is in the appeal bundle.
Yeah.
I shan't take you to it, but that is there in the event it needs to be considered. One of the important aspects, if I may, is if I can take you down to paragraph 39. This gives the contextual considerations of the Solicitors Act. And you'll see there that it is concerned with the right to assess the solicitor's bill of costs. Again, underpinning the idea from Herbert that an AT premium in the cash account falls outside the context because it is not simply an item of cost, but a non-litigation expense. And the focus is outlined there as well, that the focus is on the proper amount to be charged, having regard to whether they've been reasonably incurred or reasonable in amount. I say that that again is important context when one cross-references that with Herbert. If I can move you then on to paragraph 43, please, which is on the next page. This outlines the purpose of the regime, and again, this is where the notion of consumer protection is brought in. I have three things to say about this, if I may. That the notion of consumer protection between a solicitor and a client has to be understood by the framework which Section 70 creates. As a consequence, when one is undertaking an assessment of cost, one is not concerned with every single aspect of consumer protection in between a solicitor and a client. It is concerned with the consumer protection towards whether the costs have been incurred are reasonable in amount or reasonably incurred. Put otherwise, the element of protection which is afforded by the Act is concerned with protecting against excessive costs.
Yeah.
It's not a wide-ranging consumer protection function which incorporates matters external to the assessment. There are, of course, other pieces of legislation which deal with that, for the Consumer Rights Act being just one example. But that is not, those broader, wider concerns are not the context and the purpose of this particular piece of legislation. So where, in my submission, the claimant's case is founded upon a more merits-based invitation to this court to permit the duty to certify and determine the cash account beyond the function and purpose of simply assessing whether the costs are reasonably incurred or reasonable in amount on the basis of consumer protection. In my submission, that is to distort the purpose of the Act and thereafter distort and expand impermissibly the consumer protection role that the Act in fact has, as properly interpreted. And indeed, the claimant's own submission to the court below as to the purpose of the Part 18 questions is recorded in the judge's decision at paragraph 39. And that was an acceptance that the intention of the Part 18 request was going to breaches of the Financial Service and Markets Act, not to whether the item was excessive or unreasonably incurred. Having framed that up, perhaps if I can now go through the section 70, subsection 7 words itself, you'll find that behind tab 1 of your authorities bundle.
Just before we do that, I wonder if it would be useful to look at PD 46 to see what we're talking about when we talk about a cash account.
Yes, of course, my lord. That's at page 115.
Yeah, well, if we start at 114 in paragraph 6.6.
Yes, that is concerned with...
We're talking about a breakdown of costs.
Yes.
And subparagraph B tells us that in applications under section 70, the cash account showing money received by the solicitor to the credit of the client and sums paid out of that money on behalf of the client, but not payments out which were made in satisfaction of the bill or of any items which are claimed in the bill. So the cash account, as I understand this, is meant to be something separate from the bill. And what's in the cash account is not in the bill.
Yes. Exactly, my lord. So it is as I say, the function that it serves is to give an understanding of what's been paid and what hasn't been paid. So those don't go to the items in the bill of course, because that's what the items that the solicitor is claiming by way of their charges.
When we look at section 70, which talks about assessing the bill, that would on its face appear to exclude the cash account, which is not part of the bill.
Yes, my lord, yes, absolutely. But of course, it's not that the cash account doesn't play a role or a function in the assessment. It's that, as I say, it has to, in order to certify what is owing to the solicitor, one has to have an understanding of what has been already paid to the solicitor. So that's where, in my submission, the cash account comes in. It's not that the court is there to assess the cash account, because that expressly falls outside that which the court is directed to do. It's simply that the cash account, as I say, is the payments on account, and thereafter it's simply to enable the certification of the cash account itself.
So is it fair to say that it's simply a source of information? The cash account is there to inform the cost judge how much the solicitor has received or has not received, and based on that information, the judge then looks at what else is claiming above and beyond what he's already received.
It's what else is due
to
not
him,
what
yes.
else is being claimed. Absolutely,
He's looking at what's being claimed in order to see whether it's fair, proportionate, etc., etc.
Absolutely, and that's in terms of the assessment of the
Yes.
bill. But then what one happens, of course, is that one goes through the items in the points of dispute against the bill or the breakdown. One then comes to an amount at the end which is owing, or which is the assessed amount on the bill. Say that's £1,000, just for argument's sake, there then needs to be an understanding of what the client needs to pay to the solicitor. So there has to be information, as my lady quite rightly identifies, as to what has previously been paid. If there's been £100 paid, the court needs to know that, because it then has a duty to certify what else is due, which will be the £900.
So to take your example, the bill is assessed £1,000. The solicitor holds on the cash account a credit to the client of £100. Therefore, the cost judge, in certifying what is due to the solicitor in respect of the bill, certifies £900.
Exactly, absolutely. And that's the amount to be paid over. Yes, and that is the function and the purpose.
So what is in the cash account isn't subject to an assessment that might be queried on the basis of the solicitor being a fiduciary. Other proceedings.
Absolutely. And the prime example being under Part 64, and the duty between a trustee and a beneficiary. And in the duty there and the language there, interestingly, in my submission, is that there is an ability to verify. And that is missing from the language in respect of the cash account here under Part 46. It may be the same letters, it's both the same numbers, the alternate way around, 64 and 46, but obviously it has a different power in my submission.
Right.
My Lord, do you need me to take you through subsection 70 and subsection 7?
Well, it's central, so perhaps you'd better.
Thank you. So if I can take you back to that, please. It's behind tab 1. What you'll find here at page 4 is the complete code. It starts at subsection 1, which concerns the rights to have an assessment at all. It then moves, as I've said, through cradle to grave. It determines limitation provisions as to when a solicitor is unable, a client is unable to have an assessment. That's under subsection 4. Importantly, what one will see there is that the limitation provision under subsection 4 is predicated upon whether there's been a payment in respect of the bill. That was the decision which was determined within Menzies. So there is other sections here, being subsection 4, which do determine issues of payment. So it can also be that the issues in the cash account could be important as to whether there is a legitimate argument as to whether matters have been paid or not. So in my submission, again, it goes to the understanding that it is important information for the court to have as to when previous payments on account have been made or not. The importance of that is that the understanding of certify sits within the wider context of Part 70, which also includes questions of payment or not. One then gets over the page to subsection 7, which is the key provision within this appeal.
Well, is that right? I mean, I would have thought that subsections 5 and 6 are of some importance because that tells you what it is the cost judge is actually supposed to do. He's supposed to assess the costs, the profit costs, or the costs other than profit costs, but it doesn't say that he should be assessing the cash account.
Yeah, well, yes, my lord, that's quite right. It's not within any of the appeals skellies or at all, but you're absolutely right. That does cover the scope of the assessment, and then that is recorded within the order for the assessment itself. And under subsection 6, that gives the court a power to limit the assessment to any particular element of the charges, in particular the direction towards particular profit costs or costs other than profit costs. So there is a limitation within the assessment to confine it if appropriate.
And that's what the claimant asked for?
The assess for the assessment is success fee. Yes, absolutely. We then get to subsection 7. And the express language there is that there is a requirement of the costs officer to assess not only the bill, but also the cost of assessment. I pause there. This underpins that which I've just taken, my lords identified under subsection 5, so that the assessment is of the bill and the profit costs, and also the cost of the assessment. There is no language there which is extended to assessing the cash account. There is then the conjunctive and, which is indicative of the further power, and that power is a different power, and the language there is to certify what is due. It is not to assess what is due or assess any items in the cash account, but the function is to certify what is due to or by the solicitor in respect of the bill and also in respect of the cost of assessment. So the function and purpose is to understand, as I've said, what is owing to the solicitor in monetary fiscal terms.
Well, its purpose is assessing the sums the solicitor is claiming.
That's the purpose of the assessment itself, my lord, yes. That doesn't extend to the sums that is owing to the solicitor after the assessment. That is the duty to certify, and there is a distinction to be drawn in my submission between assessment and certify. And what is important is that the function to assess is not attached to a duty to certify what is due, because of course at that point the assessment has already been completed.
And in any event, an investigation into what is or isn't, what has or hasn't been paid by the solicitor isn't an assessment function, is it?
No, it's not. And that's the point that my lord put in respect of subsection 5. It's not a function at all. And actually, if I need to make that point good, what one can see from part 46, if I can take you there to 46.9, which you will find at page 96. This is the basis of the assessment between solicitor and client. If you have that, you'll see from subsection 1, this rule applies to every assessment of a solicitor's bill to a client except a bill which is to be paid. One doesn't need to concern oneself with that. But again, the language is to assess the bill. It is not to assess a cash account. And then subsection 3 deals with the basis of the assessment and the presumptions which are to be applied between the parties. And if one then goes back, if I may, to page 115, which is the practice direction, you'll see there under subsection that practice direction, as I said, is that after the detailed assessment is concluded, concluding the function of assessing the bill, which is directed under 46 subsection 9, the court will, so at this point the court is functious in respect of the purpose of 46.9, that having been completed, and one can understand that by looking through subsection A, to complete the court copy of the bill to as show the amount allowed. So again, at this point, the assessment has been concluded. The court has decided what the reasonable allowance of the cost is, applying 46.9(3) assumptions and presumptions. That process having been completed, the court in my submission has then discharged its duty under subsection 5 of section 70 of the Solicitors Act. And now one moves forward to determining and settling the duty to certify under subsection 7. Again, coming back in my submission to the point that subsection 70 is sequential and one moves to it sequentially. The then duty is to determine the result of the cash account. Again,
what is in the final cost certificate? What does such a document actually say in practice?
it contains the amount which is being allowed on the bill, and in certain circumstances it also can contain the amount which has been assessed in terms of the cost of the assessment. So both of those figures are the amounts that have been assessed within the assessment itself.
So does that certificate give credit to the client for any credit balance on the cash account? I mean, does it say I've assessed the bill at £1,000, there's £100 credit on the cash account, therefore the client owes 900? Go back to your example.
I'm going to pull that up for you, my lord. I don't want to get the language wrong because
Right.
it seems that the language is going to be quite important for that. So I have a copy of it up. I can send it to the court if that would assist.
Yeah.
Thank you. So it says, in accordance with, I'm going to read it out because of course it's not in front of you. That's permissible. In accordance with, and then identify the document giving right to the assessment. The judge has assessed the total cost at, and then there's the figure for the bill, and then including the costs of the detailed assessment, which is why I say sometimes some judges just fill in both figures separately. Some judges complete the figure to be owed, including the cost of the assessment. That seems to be determined by the individual judges who are doing the assessment. And then it says this: you must pay the balance of, and then it has an amount to be inserted to the claimant within 14 days of the date of this order. So again, sequentially, it notes the amounts to be allowed on both the assessment and the cost of the assessment.
So on your argument, if there is the £100 credit to the client in the cash account, it goes into that final bit saying you must pay, and the £100 will have been deducted from the assessed bill plus the cost of the assessment.
Absolutely, yes. So again, has two separate functions, two separate sections. It also, just for completeness, then goes on to deal with interest, but I will arrange for that to be sent to you, my lord.
Right.
So if we can then turn perhaps to the cases and the 19th century's authorities, which I say are relevant. I can take you please first of all to Jones and James, that's at tab 8. I suggest that this gives the clearest example of the understanding of the role and function of the cash account. In that respect,
This is before the 1843 Act.
it is before the 1843 Act, absolutely, my lord, yes. So what happens is that this is before the 1843 Act, but then when one goes to Cooper and Ewart, which is after the 1843 Act, it applies Jones and James. So this is the, and also if I may, just to complete that submission, the language is the same, which is used between Cooper and Ewart and also Jones and James. So I say that nothing particularly turns on the fact that it is from one of the older statutes, forgive me. And also it's not in dispute within this appeal that the Jones and James has got no relevance at all. The claimant being silent on this point. So this is a decision of Master of the Rolls, Lord Langdale. The head note, I suggest, does succinctly record the decision of 4 factors that under a common order for assessment, which it is exactly the same form as provided for now within subsection 70, subsection 7, the cost judge is not allowed to take an account rather than take into account, but take an account of pecuniary matters which are foreign to the bill of costs, but comparative to that, he is authorised to take an account of the monies paid by the client on account for the express purpose of paying the bill, or if money has come into the account of the solicitor and in the solicitor's hands generally, but then the client then agrees for those sums to be utilised for the purpose of paying the bill, those can also be taken into account when determining, or taken into the account on the cash account. So in my submission, I say this authority stands for the proposition of 2 things. That the purpose of taking the cash account is to see the payments on account, and second of all, that the purpose of working out what is then owed following the assessment, and that taking this into account, the cost judge has no authority to take an account of pecuniary matters between the parties which are quite foreign to the bill of costs. The question is whether the transactions amounted to payment of the bill or an agreement to use the money to discharge. And you'll find that, if I may, from paragraph at the bottom of page 131, the provision that is sidelined. confirming that the master has something to do further to taxation, which is as aligned with the function and the purpose now of section 70 and also the practice direction. And the second paragraph from the end, if one looks 2 lines up, tabbed in about halfway, it was therefore necessary for the master to do something in addition to the taxation. Again, in my submission, that aligns with the function of the practice direction. And then he says over the page at 132, I quite agree that upon such an order, the master has no authority to take an account of pecuniary matters between the parties which are quite foreign to the bill of costs. But the question here is whether the transactions amounted to payment or appropriation. And that, in my submission, succinctly puts the purpose and function of the cash account. And going back to the position in Herbert, once the decision had been made that the AT premium, being a non-litigation expense, falls outside the scope of a section 70, it falls outside, in my submission. It amounts to, forgive me, it being foreign to the bill of costs. And that is something which the master has no power to take an account of. You then see, just by way of practical example, the last paragraph, he goes through the practical example as to whether there had been payment or not, and whether it was, and that it was proper to continue to take into account and inquire whether the solicitor had in his hands money applicable to the payment of the bill, and whether he had the right to retain it for that purpose. So practically what one sees from that authority, in addition to the principles, is that the Master of the Rolls was working through the practical application of what had been paid on account and what had not been paid on account. And what you will not see there is any reference at all to being able to interrogate any of those particular items to how they have been made up. We then, if I may, turn to the matter of the next authority, which is Cooper and Ewart, which is behind tab 9. My Lord preempted my point about this being a case which was decided after the 1843 Act. What one sees is that it confirms the position in James and Jones and the duty of the cost judge to ascertain whether the bill has been paid. Sorry,
This is governed by the 1843 Act, is it? Because I see the bill of costs was delivered in 1838. The order was made, and the order for taxation was made in 1838.
I forgive you, that's not something that I picked up on. I went from the 1847 at the top.
Sorry?
But in any event, even if I'm wrong on that, where we get to thereafter is Lee and ex parte Neville, so the point still gets made good in that authority anyway.
Right.
But what one sees in any event still is that the same language is used even before the 1843 Act as to the duty to certify, and in particular you'll see from the head note right at the top of Cooper and Ewart, under the common order for taxation, that being the duty, it's the duty of the taxing master for the purpose of ascertaining whether the bill has been paid to inquire. What one sees here is that the common order for taxation is set out. You'll find this over the page at 134, starting from the citation at 365. And that common order is actually set out on the page before, at page 133 from 364.
Yeah.
And you'll see there, importantly, the similarities to a significant extent, and I say material similarities between the power under subsection 7 and also within section 70 more broadly, and the power under the old common order, it seems to me in my submission that what has happened is that there's been the matters simply have been on a statutory footing from 1843 onwards. My Lord, I can address this point, perhaps finding the statute over the luncheon adjournment, but there were the statutes before the 1843 Act, which were consolidated, which still had in my submission the same terms materially. If it's going to be a material point, I can certainly turn those up to show that the language is the same. The authority of Menzies in my submission, though, still stands for the proposition that these authorities are relevant and continue to be relevant to the understanding of what the subsections were in any event. So my point is this, is that nothing particularly determinative turns on it. There are 6 points, if I may make, to draw out of importance here. The decision was of the Lord Chancellor, and you can find this starting at page 134. And the simple question before the court there was whether the court had properly discharged its functions in obedience with the order. Under 365, I've taken you through that already, that the duty, therefore, is simply to inquire whether the bills have been overpaid. Again, that duty is confined and defined to whether they've been paid or not. There's no further duty at all in my submission to interrogate the cash account in the way so suggested. He then approves the application of Jones and James. If I can take you to the final paragraph, which starts with respect to the other case, it's just shortly above that, 5 lines above. On the contrary, in Jones and James, he used these very words: for the purpose of ascertaining whether there has been any payment on the bills, it was proper for the master to inquire whether he had in his hands any money. So he approves the application of Jones and James. I can take you, please, to just slightly above this as well. If one looks to 366, it's the end of the paragraph just above. If one looks 5 lines up on the right-hand side, it starts, I find the court continuing involved in the difficulties in saying what is or is not taken into account in the exercise of its summary jurisdiction.
Wait a minute. Oh, I see, yes.
So this is a summary jurisdiction. It is not an involved jurisdiction. And in my submission, the claimant's interpretation or urging on this court would involve a very detailed process of going through whether there has been breaches of fiduciary duty, requiring witness evidence, disclosure, etc. And that would pull against the notion of this being a summary jurisdiction. So again, in my submission, this Cooper and Hewitt authority is of importance to the limits of the assessment. Again, just to confirm and just to complete the submission, over the page at 135, at the very final, the top paragraph there, the master is required by the present order to ascertain whether the bills have been overpaid.
Yeah.
And to do that, he must ascertain the sums of money in the solicitor's hand. So again, no duty in the way that the solicitors are, so the client is so suggesting. And if I can take you please to In Re Lee, a solicitor, which you'll find behind tab 10. Notable that this authority is the first time that we see the word cash account used. On the head note there, it says on the right-hand side, 4 lines up from the paragraph, taxing master required a cash account. But in this instance, what the factual circumstances were quite unusual. What it concerned in terms of the factual background was the payment of a solicitor's bill to the executors of the solicitor's estate following his death. The solicitor had been retained by the client generally and in particular in respect of various mortgage transactions. He also received rents into the client account. So in that sense, there were mixed funds in the client account, both funds to be paid to the solicitor's charges and also the monies belonging to the client in respect to the rents received. During the solicitor's lifetime, money had been taken broadly by way of deductions, but then after the solicitor's death, the executor sent in a further bill of costs. The order was obtained for the assessment and also the usual order for directing the master to certify the balance, and that was where the master required the cash account to be brought in. And this seems, in my submission, as I've said, is the first point, and that solidifies the language used previously of that the solicitor has to bring all books and records, etc. This has now been curtailed to being understood to be known as a cash account. The first attempt to the cash account was not accurate, the reason being the solicitor didn't have any records, or the executor couldn't access any record because there'd been no accounting records kept. So again, this gives an understanding in my submission that the accuracy of the cash account is towards the payments received and whether the payments received were accurate or not, rather than whether any constituent payment in and of itself is an accurate figure. The second attempt was also not accurate, and the master found he could not therefore take the cash account, so consequently found that he could not certify any sums due, so nothing was allowed. The master of the rolls reversed this. You'll find this at page 137. Halfway down, the executor took objection certificate, and ultimately the master of the rolls ordered payment of the tax costs, deducting the costs of taxation. The argument that was put forward is recited there. Now, it's not something I would usually take the court to, but in my submission, this may be of some assistance, is that the onus was said to be the appellant on the solicitor, on the solicitor to make out his account.
So let's just understand what happened before it got to the Court of Appeal. The taxing master taxed the bill at £748 odd, but he said that the solicitor had received money on the client's account, but he couldn't produce a proper account, therefore the solicitor was entitled to nothing.
Correct.
And that's what the Master of the Rolls reversed.
Correct.
He said, no, you must pay the sum that the taxing master, for which the taxing master taxed the costs.
Absolutely, but the important argument that was on before the court in Neville was where the burden lay. And the argument from the client...
What Mr. Jessel is arguing is that the burden is on the fiduciary to justify the payment.
Absolutely, yes, absolutely. And that was rejected. And that can be seen from page 1, the very top of the paragraph at page 139. The question preceding this, whether the solicitor is to be deprived of his costs in the way my lord has just set out, and the conclusion being, I think there is no ground for the contention that the onus is thrown on the solicitor. That is important because paragraph 67 of Mr. Justice Sweeting's decision records that the duty is on the solicitor to do exactly that. And that is wrong as a matter of law.
Sorry, this is the judge's decision at paragraph?
67, Lord.
67?
Yes.
Yeah.
You'll find that at page 127.
Yes.
When he says it is and has always been incumbent on the solicitor to satisfy the court as to the accuracy of the cash account, not for the client to disprove it. That's simply wrong as a matter of law. So taking into account all of these authorities, in my submission, they all support the solicitor's contention as to what the duty and function of the cash account is. There's certainly no ability in my submission which is to be gleaned from either the express construction of section 70 of the Act, or the practice direction at 6.19 to support the notion that one can interrogate the cash account in this way. Nor in my submission is there any support in any of the authorities which are applicable to determining and understanding the application of the Act. Indeed, they all support the solicitor's contention. There is no support anywhere in my submission, either in the Act or in any of the authorities, to support the notion that the client now says that one can interrogate a cash account to the extent due. And if you accept that in my submission, it follows in respect of the point comes then to be whether the dispute is within the scope of Part 18 questions or not. But perhaps before I move on to that, I can perhaps take you through the case of Edwards, which is the decision of Mr. Justice Ritchie, which is...
Well, just before we go there, you've shown us section 70 and you've made your submissions about it. You've shown us the practice direction and the definition of cash account. We also have CPR Part 47, which is the procedure for a detailed assessment.
Yes.
And if we look at Rule 47.9, which deals with points of dispute, we can see that the paying party may dispute any item in the bill of costs by serving points of dispute. Now, your argument so far is that the cash account is not part of the bill of costs, it's something separate to the bill of costs. And therefore, if that is right, it might be said that it follows that questions about the cash account can't be raised in points of dispute because points of dispute are limited to disputing items in the bill.
Absolutely, my lord, and that's the direction which it says. The practice, in practical terms, is that one has to, of course, in terms of complying with the practice direction, which is at 8.2. You'll find that at page 56. In particular, you'll see that this is the form and content of the points of dispute, and that one must identify any general matters of principle which require decision before individual items in the bill are addressed. So it has to. So there is potential scope, and I suppose I have to accept this, that there are perhaps sometimes items in a points of or disputes within points of dispute which do not necessarily immediately correlate with the bill itself. So, for example, the question of proportionality. That would be applied to the total costs.
Well,
so,
it might not apply item by item, but it would still be a dispute about the bill.
yes,
Cash account.
yes, absolutely. That was going to be, yes, that, forgive me, I was making the point in perhaps a long-winded way, is that it's not necessarily contingent on items within the bill necessarily.
No, not necessarily individual items, but it's the bill.
It is the bill. And even so, arguments in respect of a retainer, by way of example, still, which underpins the items in the bill, still goes to issues in the bill. So when one is looking at what subsection A of paragraph 8.2 goes to, it's still confirmed that the items in the bill are the matters to which the points of dispute go to. And that, of course, was the decision that was upheld by Lady Justice Appellant of this court in respect of Ainsworth and Stewart's law, that the items in the bill are the items to which the points of dispute and thus the assessment go to.
Right, now you want to take us to Edwards?
Yes, please, that's behind tab 31. I said I would make good earlier my point that the arguments before this court simply weren't before Mr. Justice Ritchie. And what one can see there, if I can take you perhaps to 482 and then across to 483, I'm not going to take you through every single one of those, but what the court will note is that the authorities, particularly in respect of Jones and James, Ewart and Cooper.
Oh, so you want to look at the cases cited?
Yes, so you won't see there, for example, Jones and James or Ewart and Cooper. That is important because it goes to the point my lord put to me this morning as to whether I have to say that Mr Ritchie was wrong in his decision in Edwards and Slater and Gordon.
You'll have to help me about the format of the costs law report. When it says cases cited, does it mean cases cited in the judgment or cases cited to the court?
Cases cited to the court, my lord, as I understand it. If you see, it is the cases cited to the court. Sometimes what you see thereafter is cases which were cited to the court in addition to those which were cited, and it's not fair.
Right.
So these are the totality of the cases before Mr Justice Ritchie,
Yeah.
which is perhaps unsurprising then when he concludes. I can take you please to page 542. This is where he's dealing with the treatment of the cost judge.
542,
Yes, my lady.
which is a very long judgment, isn't it?
It is a very long judgment. There were 3 points which were dealt with within Edwards and Slater and Gordon. It was disclosure, it was an application as to whether disclosure under Part 31 applied to Solicitor Act matters. There's also a question then of whether there ought to be security for costs ordered. Those took up the meat of the judgment. The Part 18 request, which was the third issues, did not come in until paragraph 207. And in that respect, the first instance judge, again, Senior Costs Judge Rowley, who is concerned with this first instance decision, decided, and it's set out there at paragraph 218, he puts out the intention of the cash account, which is that which this submission made before this court, that it is simply a record of the financial transactions. He sets that out at paragraph 30 and 51, then goes to paragraph 52, internal, that as a consequence there is no possibility, in my view, of the court in the Solicitors Act proceedings making any inquiries as to the adequacy of the sum of money in respect of the ATE. And Mr Justice Ritchie said that in that respect the judge fell into error. In my submission he was wrong to do so, because he simply hadn't been, and one would anticipate that had his attention been drawn to Jones and James, that he would have found that actually the recitation from the senior cost judge is exactly that in my submission, which mirrors the understanding of Jones and James, which the senior cost judge set out at paragraph 30.
Help me about this. I personally am having difficulty in reconciling what Mr Justice Ritchie said in paragraph 219 with what he said in paragraph 221. He says the cash account can't be signed off in the assessment. No order can be made by the cost judge unless the items in the cash account are accurate and certified. If they are in dispute, that dispute must be resolved. Then he rejects that the assessment of the premium can occur in the assessment through the backdoor route. It's usually more of a chancery matter. But secret commissions may or may not be solely for chancery. And if evidence is required, the cost judge will need to decide how much and where the best form for determination is. So going on then to 223, he seems to suggest that the costs judge might transfer something to the Chancery Division.
What that something is quite unclear. In my submission, the context must be, in order to understand paragraph 219 and 221, must be that he's accepted the principle that the cost judge has a jurisdiction to somehow adjust the cash account in the way suggested. And that can be taken from where he says the judge fell into error at the start of 219. So the idea is that the cost judge in Mr Ritchie's decision, as a matter of context and subtext, is that the cash account can be adjusted in the way as suggested by the claimants. Because what he's doing is rejecting paragraph 52 internal of the cost judge's decision, that there is no possibility of the court in a Solicitors Act proceeding making any inquiries as to the adequacy of the sum of money. So what he's doing is he's directly rejecting the cost judge's decision on that, although he doesn't go on to expressly say, I accept that the cost judge has a power to adjust an item in the cash account on a merits-based approach. That in my submission must be the subtext, but I accept that it's not exactly expressed in the clearest of ways. What one then sees is that he determines it almost as a case management decision, saying in terms that, look, there is a dispute to be had, because the issue in Rubenheimer was that there were direct evidence of commissions there paid. So that being again distinguishable from the case before this court today, and that because there was a live issue, that had to be dealt with somehow.
I'm just not at all clear what it is that Mr. Justice Ritchie is contemplating. A dispute arises in the assessment about whether or not there's been a secret commission. Let's assume, contrary to your argument, that is a permissible matter to raise in the assessment. The assessment can't be completed, says Mr. Justice Ritchie, until that dispute has been determined. The cost judge sends it off to the Chancery Division for somebody else to decide. And when that somebody else has decided, it comes back, does it, to the cost judge? And as a result of the outcome of the dispute, which has now been decided by the Chancery Division or the County Court, whoever it is, the cost judge now signs off the assessment. Is that the process that is being contemplated?
It would appear so. The difficulty with that, I mean, there are a number of difficulties, but the duty to certify the bill, of course, as I've set out, only goes to the amounts to be paid over to the solicitor in respect of matters in the bill, and it doesn't include non-litigation expenses. So Mr. Justice Ritchie seems to be contemplating a situation whereby the cost judge has assessed the bill, let's say for the £1,000 of earlier, that there is an ATE premium of £250. He has a concern about that being in the cash account. There's also the £100 payable. So he's saying that he can't certify the amount due to the solicitor, the £100 taken off the £1,000 being £900, because he's got a concern with a different category of cost, being the £250 in respect to the ATE premium. But when one is certifying the amount due, one simply works out two factors, the amount of which the bill's been assessed by, and then the payment on account. What
Well,
Mr. Justice Ritchie is getting...
The thought underlying this, surely, is that the solicitor has charged £250 in the cash account for the ATE premium, but has received a commission of £25, let's say, and that £25 ought to have been credited to the cash account, so that instead of there being £100 in the cash account, there ought to have been £125 in the cash account. That's the logic, isn't it?
It is, but it's flawed. And one of the reasons it's flawed is that it's taking into account £25, which wasn't paid towards the bill. And that's not the purpose of working out what is owing on the cash account. So what he's doing is he's comparing apples with pears, and he's trying to reduce or increase the amount that the client has paid on account. The £100, increase it by £25 to take account of the £25 referenced, when that is, in my submission, an impermissible approach, because it's taking into account matters which are non-litigation expenses.
Right.
I can see all of that. I mean, I'm still struggling with 219, where the judge says can't sign off on the and make no order for sums to be paid unless the items in the cash account are accurate and certified. If they're in dispute, the dispute must be resolved. Well, yes and no. If it's unlikely that there's going to be a factual dispute as to how much money has been received by the solicitor.
Well, sometimes there can be.
And if there is, would you accept that that would have to be resolved?
Yes, absolutely,
Yes.
because that falls within Coupland and that falls within Jones and James. What Mr. Justice Ritchie here wrongly seems to be assuming is that one can take into account all the items in a cash account.
Yes.
And that wider understanding, rather than just the narrow items in a cash account in respect to which the bill's being paid. To give the example in Re Neville, where there were items in the cash account which related to rents received, Mr. Justice Ritchie's position would be that the court had to take into account all the rents when working out whether the cash account is accurate and certified by the cost judge, rather than simply working out the amounts paid towards the solicitor's bill and settling it off in terms of payments on account.
So in Re Neville, what had to be done was an ascertainment, because the accounts were such a muddle and everything was intermingled. The taxing master in that case had to decide how much of that money was actually paid to the solicitor for his bills, as opposed to received by the solicitor by way of rents and not with the agreement of the client put towards the bills.
Absolutely. And taking more of a practical approach to it, if we have the mixed funds within a client account and the cash account, on Mr. Justice Rich's understanding, because it is termed, or certainly promulgated in the respect of the entire cash account being accurate, one would have to go through the duty on the cost judge to check every single item. Are the rents going to be correct? Is that a matter on the assessment? And another example being if there is, and this is an example concerning whether there is a secret commission perhaps, if a solicitor has been instructed to act for a client generally who has a number of different property portfolio, and the client says, I'd like to sell one of my properties, please. Can you please recommend an estate agent? The client then the solicitor recommends the estate agent. The solicitor then, once the transaction has been undertaken, receives in the property funds on receipt of sale, forgive me. So the money of £100,000, say, sat within the client account, and out of those fees, the solicitor has to deduct the estate agent's fees, stamp duty, etc. Is it the case that the cost judge on assessment has to look to the stamp duty because it's in the client account? Is it the case that if there has been a payment to an estate agent, the cost judge is going to be taxed with considering whether the estate agent's fee has a secret commission in it, such that the cash account can be adjusted on that basis? So the position of Mr. Justice Ritchie in my submission goes way beyond that which a cost judge is entitled to take into account.
Say the limit of the inquiry is, the proper limit of the inquiry is how much did the solicitor get paid for his services?
Paid on account towards
Paid on account of his services.
Absolutely, which is exactly what is said in Jones and James, and exactly what is said in the later authorities, and it aligns with
not whether it was the right amount, the wrong amount, whether it was too much, too little. It's how much has he received, and then looking at the rest of the bill and what else he's claiming. Is that too much, too little? Overall?
Absolutely, it's a very limited factual inquiry. It's a very limited factual inquiry, and again, it goes to the purpose of what the cost judge is tasked to do. The cost judge is tasked to assess the bill.
Putting it shortly, you say that the first question for the cost judge is, how much should the solicitor be paid for the work he's done?
Yes.
And the second question is, how much has he been paid so
Absolutely. Far? And then applying a mathematical equation, has he been paid too much? Has he not been paid enough? And then that allows the final cost certificate to be completed, directing whether the solicitor needs to make a refund or whether the client needs to pay more money on account. Pay more money towards the bill. That is the entire process.
Right. So I think you do say then that Edwards is wrong.
Yes, I do. I have to. I think I'm constrained to that. But that again, as I say, it is a proper interpretation of not only the rules but also.
Well, it's per incuriam because it's contrary to higher authority, which you say is still binding.
Absolutely.
So you say it has to be monies that have been received from the client?
No, because the expression within Jones and James is actually twofold. It can be monies expressly received from the client which is paid over solely for the purpose of settling the bill, or if the solicitor has come into monies generally and the solicitor and the client agree that those monies can be used towards discharge of the bill.
The client can appropriate it.
Yes, absolutely.
So if the tenant pays the rent to the solicitor and the client says you can use this rent towards your bill, then that's an appropriation by the client.
And the understanding of appropriation aligns in my submission with the understanding of settlement of account that one sees in Menzies.
Yeah.
And again, it comes back to the cohesive interpretation of the entirety of Section 70.
Right.
So a secret commission might be said to be held to the account of the client, but it hasn't been appropriate. Is that the point?
Well, the difficulty with the secret commission argument, one of the difficulties in my submission is that it requires a factual inquiry as to what in fact has happened and how the solicitors have, if say on the case that there is one, how the solicitors have dealt with it. Because it could be that such that it comes back as a business expense somehow, in which case it may go into the office account. It doesn't always follow that it has to be put directly into the client account, but in any event, that requires a factual investigation, which simply falls out the scope of what one is doing when one is certifying the cash account.
But as I understand it, you're not saying there is no remedy,
There is a remedy, it's under Part 64.
but it's just not Section 70. It's not here.
Absolutely, exactly. And one can take the example of Hopcraft, which is on the financial mis-selling cases. That is an entire jurisdiction and an entire segment of the legal industry devoted to financial mis-selling and secret commissions. And what one sees there is that they're dealt with in Part 7 in either the county court, depending on the value, or perhaps in the High Court.
Under the Consumer Rights Act now, because the Supreme Court told us there's no other way of dealing with them.
Yeah.
You say it would be a claim under 64(2)(a), and under the practice direction it would be...
Yes.
2A1.
Absolutely, it would be under 2A1. And what one sees there is that there are various requirements which have to be satisfied. But it also sets out a procedure. So if one goes to 64.3, that they are under Part 8 claim forms. And then in the practice direction at 64A, there is an ability for these types of hearings to be determined without a hearing if certain requirements are satisfied. So there is a remedy. It's simply not this one.
Yeah.
And forgive me, that's only one example of a remedy. There could also be the remedies under Part 7 for breach of fiduciary duties or professional negligence, however they are framed, but it's simply not this position. And perhaps that is a good way to segue, if I may, into the breach of fiduciary duties position. This does sit somewhat across both questions in respect of Part 18 thresholds and also Section 70, but I'm going to deal with it now, if I may. The position before the Costs Judge, you'll see is recorded at paragraph 39, which is at page 211 of your core bundle. What you'll see there is that actually the purpose of the claimant's questions was set out in very stark terms. It says, but Mr. Carlisle made clear in oral submissions that such lack of disclosure may open the gateway to all manner of relief and remedies via provisions such as the Financial Services and Markets Act. So that's the purpose and function of the Part 18 questions. It does cross over in terms of the threshold application, but it also has a facet of that question, whether the Costs Judge has a jurisdiction to determine breaches of fiduciary duty within the confines of a Solicitor Act assessment. There are one authority and a High Court decision that I'm going to invite the court to consider, but perhaps if I can take you through somewhat atypically the High Court decision first, because that does in my submission set out quite clearly what the Court of Appeal case in Re Macy and Carey determined. This is the decision of Lisa Jones and Richard Slade and Co. It's the decision of Mr. Justice Johnson, and you'll find it behind tab 33. actual position in respect of Lisa Jones was that, again, it arose out of a solicitor-client assessment, but there had been an agreement between the solicitor and the client to settle the costs prior to the assessment being requested. So the question was whether the agreement to settle a cost could be set aside for reasons of undue influence and financial duress. And the short point within Jones and Richard Slade can be seen from the head note at page 565. It's about 6 lines up between G and H. This was the findings. However, Section 70 did not permit the court to embark on what was in effect a freestanding inquiry into the question of whether the agreement ought to be set aside on the grounds of undue influence or economic duress, which involves the exercise of a distinct equitable jurisdiction which forms no part of an assessment of costs. And accordingly, that the court does not have the power to set aside the parties' agreement when assessing under subsection 70. That decision is directly drawn from the authority of In re Macy, which you'll find at page 572. Set out there, and it determined that the court distinguished between a situation where the issue went to the whole action being rendered useless by negligence, or whether isolated items of costs which were unreasonably incurred because of the isolated negligence could be determined. And again, it's concerned with the outer limits of a Section 70 assessment, but this time within the understanding of what can be argued or not in the terms of negligence or fiduciary duties. And the decision taken was that the cost judge had the power to disallow costs if they were unnecessarily incurred in respect of the negligence, but that there was no ability to determine wholesale actions of negligence, because the court needed to distinguish between those cases where the whole action had rendered useless by the negligence and where it was simply a case of an isolated issue was unreasonably incurred as a consequence of the failure to do the duty, his duty, the solicitor's duty, forgive me. There's then the authority of Drucker, which is considered at paragraph 27. This was a decision of Mr. Justice Openshaw, who again upheld the concept that wholesale professional negligence issues cannot be determined within a Section 70 assessment. And then the final authority considered is Stevens and Harwood, which is over the page at paragraph 28 of page 573. Stevens and Harwood is where the notion that because breaches of fiduciary duty under professional negligence couldn't be considered, as per in re Macy and also in Drucker, it must follow that all issues in respect to fiduciary duties can't be considered within the context of a Section 70 assessment. And that is seen from the claimant had been negligent and that it had breached his fiduciary duties. And he recognised that the SCCO can determine other issues of quantum, but the nature of the defence had to be raised such that it was better determined within Part 7 proceedings. So having considered those authorities, Mr. Justice Johnson went on to determine at page 575, at paragraph 39 onwards, that there is a jurisdictional limit to what can be considered within a Section 70 assessment and what can't be. He notes that there is somewhat of a difficulty identifying and defining precisely where that outer limit lies. However, he was assisted by the authorities, and the consequence is set out at paragraph 41 and 42. The test is ultimately a jurisdictional one and ultimately comes down to questions of relevance. And this can be seen from F through to G of paragraph 41. where issues of negligence are closely tied to the exercise the court is required to undertake, i.e. the assessment of the costs, that can be part of the assessment. But conversely, if a claim is issued after the expiry of the limitation, which is the example he gives, then that is a wholesale issue of negligence and that is excluded. And then he applies that, as I said, at paragraph 42 to the wider understanding of breaches of fiduciary duty, and that there was no principled reason as to why there ought to be a distinction with professional negligence to any other breach of fiduciary duty arguments which could appear within an assessment, as in this one, the issue of economic duress and also undue influence.
Is that paragraph squarely in your favour? Because what Mr. Justice Johnson seems to be contemplating is that if a breach of fiduciary duty related to an individual item of costs, that might be relevant. Now, I understand your point that the ATE premium is not nothing to do with costs anyway. But if you're wrong about that,
Yes.
then Mr. Justice Johnson seems to envisage that if the cash account, assuming it to be within the assessment at all, wrongly states the ATE premium because it doesn't give credit for a secret commission, and that could be relevant. Isn't that what he's saying there?
No, what he's saying in my submission is that one has to come down to the relevance of the test of whether an item has been reasonably incurred or reasonable in amount. So when one is looking to issues of wholesale negligence predicated upon a breach of fiduciary duty, if that is intended to have a remedy attached to it, which is something other than whether the item has been incurred as a reasonable in amount or in a reasonable sum, that falls outside the scope of the Section 70 assessment. And what one sees here is a direct position from the claimant saying that the Part 18 questions were wholly intended to go to a whole other manner of remedies and relief.
That's a different point, I understand that, but yeah, all right.
But in terms of it falls under in my submission, it falls outside the scope of the assessment because it's asking the court to determine a different remedy, the remedy to reduce the ATE premium for various breaches of fiduciary duty. And in my submission, that is not undertaking an assessment as to whether it has been reasonably incurred or reasonable in amount. But in any event, one comes back to the Herbert point. So I say there are limits to the jurisdictional test in any event. So if I may then, unless there's anything further that the court wishes to hear from me on the conclusions of the cash account point, conclude those and then move on to the Part 18 question.
Yes.
Forgive my back. The conclusions being these, that the literal interpretation of subsection 17 of the paragraph 619 of the practice direction simply doesn't support the position that is conferred by on the claimant's position to limit the duty to certify, that there's a long line of authorities which doesn't support the claimant's position, and as a consequence in my submission what that does is it frames up whether a matter is in dispute within the proceedings or not for the purpose of Part 18.
Well, there are two limbs here, aren't there? One, is it in dispute? And secondly, if it is it in the proceedings?
Absolutely.
We have to identify the proceedings first before we can decide what's in dispute, really. And your submission so far is the proceedings are the proceedings under Section 70, and what they're about is identifying, assessing the bill.
Yes, my lord, yes.
And anything else is not in those proceedings.
Yes, absolutely. And so the proceedings in my submission are defined by Section 70. I'm not sure if my lord is getting to the point that, well, the proceedings were issued via a Part 8 claim form. But in my submission, that still has to be considered through the confines of Part 70. And in those circumstances, that is what Part 18 is going to when it confirms or goes to the issue of what is framed by the understanding of the dispute in the proceedings.
Well, if we look at the claim form, which we've got in the supplemental bundle tab 2, what they're asking for is an order in standard form, pursuant to Section 70, subsection 1, for an assessment of the statute bill, and then they're asking for the assessment to be restricted by virtue of subsection 6 to the profit costs element and the success fee element.
Absolutely. And
So
what would,
that's the dispute which they raised by their claim form.
and what one sees absent from that particular claim form is one of two things. There's no reference to Part 67, which is prayed in aid by my learned friend as being something that the court can particularly take into account, because that requires the court to deliver either a cash account or a bill of costs. First of all, that wasn't a remedy that was sought, but in any event, when one looks to Part 67, it simply provides the court with the power to deliver a cash account. So I say that's not determinative. But equally,
There wasn't a suggestion that a cash account hadn't been delivered, was there?
no, exactly not. No.
I mean, certainly was no suggestion that a bill of costs hadn't been delivered, because you can't trigger Part 70 until you've delivered one.
No. Well, perhaps my learned friend can assist you on that as to why Part 67 is relevant, but it's not in these
There's
proceedings.
no reference to Part 67.
No, nor is there a reference to Part 64. So the proceedings are, in my submission, framed by the dispute in those, which is going to the Solicitors
Well,
Act.
I mean, you might say that assuming that Section 70 itself would permit some sort of interrogation of the cash account, paragraph 2 of the claim form disavows that, because it says it's to be restricted. And the only things that are going to be assessed are the profit cost and the success fee.
Yes, I see my Lord's point. But of course, the assessment can't relate to an ATE premium in any event, which is probably why there is a restriction on it. But my Lord's absolutely right. It's not named in the claim form to be part of the proceedings in that way.
And there's been no application to amend the claim form, has there?
No.
As far as I know.
Whether that be a formal application or an informal application, as we've seen with the Part 18 request, there has been no request at all. If it's the case that there ought to be the situation where the court is asked to determine the function of the cash account and whether it ought to appear on the claim form or not, that will be a matter for my learned
So
friend.
those are the proceedings. They're under Section 70, but they're restricted by the claim. We've seen that CPR 47.9 permits disputing elements in the bill. So that's what's in dispute, potentially in dispute in the proceedings. And your argument is, well, the cash account's got nothing to do with any of that.
Absolutely.
So therefore, questions about the cash account can't relate to any matter in dispute in the proceedings.
Absolutely.
Whether they're, never mind any threshold, they're just outside Part 18.
Absolutely.
Right, got that point.
Well, my Lord, if you had that point, I'm not sure I need to take you through any of my submissions on Part 18, because that is the exact point. And that was the position for the Costs Judge before him, and it's the position that Mr Justice Sweeting overturned. My Lord, I'm grateful for the indication. I shan't take up any more of the court's time on that.
Well, my colleagues might want you to.
My Lady Justice Andrews was nodding at me, so I'm going to take that as an indication that I do not need to do speaking on that. My Lord. No, thank you. Grateful. Do you wish me to address the... Pardon?
We have got the point, I think.
Thank you. I when one is always prepping these things, one can see this is a fairly obvious point, you know, why, but thank you, I'm grateful. In respect to the case management decision, that also seems to be somewhat of a quite obvious point as well. Is this something that the court wishes me to trouble them on?
Well, I think we know the principles.
Yes. Thank you. Well, in that case, my Lord, I'm not sure that there's anything further that I can assist you with. I've dealt with the primary issue on this appeal, and I say that actually what that amounts to, the cash account dispute, is the lock which unlocks the entire application. If you're with me on that point, then the case management issue and also the Part 18 follows.
The only point I would make is that the case which is cited, which is a decision of mine in Broughton and something or other.
Broughton and Cop, the Liverpool
Yeah, the
football
one
case.
about Liverpool Football Club.
Yes.
Was a refusal of permission to appeal. So
Forgive
strictly
me for
speaking,
including
it
it.
is not citable.
Thank you. Forgive me for including it. My Lord, my ladies, is there anything further I can assist you on?
No, thank you very much.
I'm very grateful. Thank you.
Yes, Mr. Dunn.
Thank you, my lord, my lady, judge. As an opening submission, I start by saying this, that the parties in my submission are arguing different appeals before you. My learned friend's submissions in their totality have focused on decisions that Costs Judge Rowley did not make. He said nothing about certification and what it meant. He said nothing about whether the cash account was in dispute or not. And in fact, as I'll take your lordship's, your ladyship, Judge 2, Judge Rowley accepted that there was a dispute and said nothing about certification. So unsurprisingly, Mr. Justice Sweeting's judgment didn't deal with those either. And again, I shall take the court to that. There is an irony, of course, in my learned friend seeking to argue that the Edwards and Rabenheimer case was wrongly decided on the basis that the case law that has been put before this court was not put before Mr. Justice Ritchie. So the Jones and James, Cooper and Hewitt cases. But of course, what is not said, although what is clear, is that none of those cases were put before Mr. Justice Sweeting or Costs Judge Rowley. Why were they not put before them? Because this was not an issue in this appeal and never has been. This decision of Costs Judge...
What is an issue then?
The issue in this appeal, I say, is this. Costs Judge Rowley found solely that he would not order Part 18 responses because there was an additional threshold test that said that the party who seeks the Part 18 request has to provide a positive case on evidence. Mr. Justice Sweeting, in the first appeal, found that there is no additional test when it comes to Part 18. And my Lord Lewison said in conversation with my learned friend 10 minutes ago what the threshold test is for Part 18. It is whether it relates to a dispute within the proceedings and whether, in all the circumstances, it's reasonable and proportionate to make the order. The decision for this court to make in my submission is this. Is there an additional threshold test which applies not just to cost disputes or this dispute, but which would apply to all Part 18 requests in civil litigation? That's the ratio of the decision of Judge Rowley. That's the ratio of the decision of Mr. Justice Sweeting. And with respect to the appellant, it simply isn't good enough to, at first instance, not put in a respondent's notice and say, we agree with Judge Rowley's decision, but for these additional reasons. Firstly, certification doesn't mean what is said it means. And secondly, this matter was not in dispute in the proceedings. They didn't do that. Then it goes to Mr. Justice Sweeting. They didn't put in anything thereafter. They haven't put in anything in this appeal. What they have done is come before this court and expected before this court to argue issues which have never been ventilated in judgments in the entire history of these proceedings.
But they go to the fundamental question of jurisdiction. And whilst I can understand why you're upset about it, fact remains that my lord has given permission to appeal on those points.
The jurisdiction issue is solely related to whether there needs to be evidence.
That's not a jurisdiction point.
Well, that is the point in the judgment.
It's nothing to do with jurisdiction. It's a question of whether or not the test requires an extra layer.
Yes.
And Mr. Justice Sweeting said there wasn't.
Yes.
I can't see that that is being challenged.
Then if that, sorry, my lady, I don't mean to interrupt. If that is not being challenged, if it is accepted that there isn't this additional threshold test, then this appeal fails straight away, because that's the decision of.
And then what? So suppose we come to the view that this was never a proper Part 18 request, whether or not a positive case is needed. Then what? Cost Judge has got to decide it all over again, or are you going to take some Henderson and Henderson?
Well, there has to be a structure. I don't. I'm standing before the Court of Appeal, so I appreciate that the submissions I'm making are of course known to you, but there has to be a structure here. If the original decision is predicated solely on the additional threshold test, and there has been no finding in any of the judgments in relation to certification or dispute in the proceedings, and then this first appeal is on that basis as well, and there has been no attempt to put in a respondent's notice, then what is in front of this court is a determination of whether Mr. Justice Sweeting's decision should stand or should
No,
fall.
I understand that, but
Yes.
let us suppose that we come to the view that it's not necessary for a person who makes a Part 18 request to advance a positive case, which is
Yes.
what Mr. Justice Sweeting decided.
Yes.
And then what? So the Part 18 request is not disallowed for that reason.
No.
It goes back to Costs Judge Rowley to decide whether there are other reasons why it shouldn't be answered, or
Well,
what?
if that is the decision of this court, and my submissions will be that that has to be right, that there isn't an additional test, but I'll make good that in submissions, then the answer is that this appeal fails, and it isn't.
I understand that. I'm just trying to work out what happens next. Suppose the appeal fails.
Yes. Then the matter can either be remitted. Well, if the appeal fails, the matter goes back to the cost judge who is undertaking the assessment.
And what are we talking about potentially? £25?
Well, quite.
Talking about an ATE premium of £250 odd.
Yes.
Let's assume there is a commission. Let's assume it's 10%.
Yes.
We're talking about £25. And that's your suggestion, is it?
That my submission, in fact, throughout, which is woven through my submissions, is that when we are talking about how to deal with these sorts of requests, is to take into account that it is a very small amount of money. It's the appellants who are suggesting that we start Part 7 proceedings.
Your clients, your professional clients,
Yes.
put in, I think it was 18 pages of points of dispute
Yes.
about a £3,000 bill. That proportion?
Well, yes, because that is, that proportionality will be can be dealt with by the cost judge when it comes to the assessment of the costs of assessment.
Turner is going to get what out of this?
I
£25?
don't know. There is also a success fee argument as well. But, my lord, those are ancillary issues. The question I say, and this is a pure question of law. This is an appellant court. This appellant court is being asked to overturn a decision which in itself was predicated upon those specific decisions. This appellant court, in my submission, cannot or should not simply say, well, now we're here, we're going to look into all sorts of other issues which have never been a feature of any judgment in these proceedings. I mean, to say with respect that isn't prejudicial to the respondent is obviously wrong.
They're pure points of law, Mr. Dunn. It's a question of construction of the rules, construction of the practice directions, and looking at a few authorities. How's that prejudicial?
It's prejudicial because this appeal, now my professional client, my client is now in the Court of Appeal, having had two decisions which I say, firstly, cost judge's decision can't possibly be justified. That was rightly overturned by Mr. Justice Sweeting, and Mr. Justice Sweeting's decision was correct, and this court is being asked to overturn Mr. Justice Sweeting's decision, not on the basis of what was argued before him or what he said in that judgment, but on the basis of other issues, case law that was never a part of anything of what he decided. So, if the appellant had wanted to turn Judge Rowley's decision into a wider point about various aspects of cash accounts, etc., the rules provide an opportunity for them to do so, and they can do so. And we all know how they can do so. They put in a respondent's notice. But if they don't do so, and then go to a first appeal, and that's decided on that basis as well, it is not proper, in my submission, to use this court to seek to determine questions which are wholly outside the nature of these two judgments. The two judgments and the focus of this hearing, in my submission, has to be whether there is this additional threshold test. That is an important point for civil litigation, because if there is an additional threshold test, if Judge Rowley was right and Mr. Justice Sweeting was wrong about that, then it means anyone in civil litigation seeking to put in Part 18 questions has to satisfy that additional test, and which is a very difficult test to satisfy for reasons I'll come to. But that is the focused nature of this appeal, and it isn't proper, or in my submission acceptable, for a respondent to an appeal to come to this court and to be arguing against matters which have never been determined in the run-up to this. Now, I say that is wholly prejudicial because the respondent was entitled and is entitled to firstly have appealed from Judge Rowley on the basis of that threshold test, and secondly, to defend the appeal from the judgment of Mr. Justice Sweeting, who found that there wasn't an additional test.
Ask what, has Mr. Justice Sweeting ever made an order?
I'm told, yes, it might be in the, my lord, it might be in the supplemental bundle. My lord, may I just check quickly? It doesn't look like it's in the bundle, unfortunately. We can certainly find it and send it. I don't think it is in the. We do have it, my lord. We do have it.
It doesn't appear to have been an order by the time the appellant's notice was served.
No.
Looking at page 9, yeah.
Yes, my understanding of. My understanding of this court is that one simply, if one applies for permission without the order, one has to wait until the order's there because the court will return it. But I'm told, and my understanding is there is an order which we can forward to your lordships, your ladyship, and judge. Yes. Would you like us to find that now, if it's an important point?
I don't think we need it immediately.
Yes, of course. But over the lunch adjournment, yeah. I can certainly do that. Thank you. So my point here is not a sort of technical point that I'm trying to make. My point here is that this is extremely prejudicial to the respondent.
What is the prejudice that you are identifying?
Firstly, the prejudice is this. The respondent, if I'm correct about the scope of this appeal, the respondent was right to make that first appeal to Mr. Justice Sweeting. The respondent, secondly, was right to defend this appeal in this court. And the parameters of this appeal should not be enlarged because that is inherently prejudicial to a respondent or to an appellant and goes against the entire purpose of the court. And I appreciate this court has a duty as a senior court of authority to consider the issues, but this is not an appeal about what certification means or whether the notice was in dispute.
But if we look at Mr. Justice Sweeting's judgment,
Yes.
looking now at paragraph 67 following,
Yes.
He says the only threshold condition is that the information must relate to a matter in dispute in the proceedings.
Yes.
No requirement for a positive case.
Yes.
So there's 2 points there. It's got to relate to a matter in dispute in the proceedings.
Yes.
You don't have to have a positive case. Then he says, a few lines further on, it's always been incumbent on the solicitor to satisfy the court as to the accuracy of the cash account.
Mhm.
Queries raised by the client place the account in dispute. And then he says at 68, allow the appeal. He goes on to say, in the event that I did so, the parties agreed I should determine the substantive application to which the appeal related in this respect.
Yes.
While the first 3 requests relate to the inception of the policy, they appear to me to relate to the matters in issue. Thereafter, the requests are squarely directed at commissions. The request should be answered. So he's determined the application. He hasn't simply dismissed the appeal or allowed the appeal from the cost judge. He has determined the applications. Now, why can't the solicitors appeal against his determination of the applications?
That is not what this appeal is. This appeal is seeking to, and it may. I'm not dodging that point, but it's beneficial to go back to what the cost judge found in this case, because this is really the nub of the first appeal and the decision that Mr. Justice Sweeting made. So it's at tab 12 of the core bundle.
Yeah.
And I have 2 numbers in the core bundle, so I'm seeking to take the court to page 211, which is paragraph
big
36.
number?
Yes, the 211 in the big number,
Yeah.
my lord, yes. Now, the reason for the judge's decision on the Part 18 request application, there was the procedural point, which is whether it was before the court. But in terms of the substance, the merit of it, it's at paragraph 40. And what Costs Judge Rowley says there is he refers to his decision in Brown and JMW solicitors, and he sets out the decision in Brown and JMW solicitors. And the court will note that subparagraph 31. This is his decision. In my judgment, there may be many situations where a party considers that opponent has possibly caused him loss but has no evidence as such. In the absence of any proof to support that suspicion, then proceedings cannot get off the ground. As indicated, the application would need to have evidence of an arguable case, and that must be the sort of threshold that applies in respect of Part 18 requests.
Well, actually, the number of his decision is paragraph 42, which is, there's no requests in front of me. I'm not going to, it would, as he puts it, be a woeful position for a court to order questions to be answered which it hasn't even seen. Now, that's really why he's refusing it.
Well, my lady, he makes what I'm terming the procedural point, which is they're not in front of me.
Yeah.
Which we will come on to deal with. But the judge goes on to deal with the substantive question. And in terms of the substantive question, that is the reason for his refusal, because, and your ladyship can see it, paragraph 41, the nub of my decision in Brown was that there was no evidence before the court regarding alleged commissions which would justify Part 18 requests being answered. In this case, I not only have a lack of evidence, but as I say, I have no Part 18 request to consider in order to see what questions have been.
So lack of evidence and lack of a request. So
yes.
Worse than Brown is what he's saying.
So there are two elements, and your ladyship, if I may respectfully say, is quite right to put this to me. There are 2 elements, and I accept that. The first element is procedurally, was the judge able to make a Part 18 request if he didn't have the Part 18 questions in front of him. That's what I would call the procedural point. That's point one.
Why is
Now-
that a procedural point rather than a substantive point? I'm refusing to exercise my case management powers because I haven't got the request in front of me.
I'm using procedural and substantive, but I accept it may well be a substantive point, a substantive reason for refusal. I agree with your ladyship on that. We will address that because our submission is that Mr. Justice Sweeting was right. But it is right to say that if this court is against us on that, for example, if this court finds that Judge Rowley couldn't or shouldn't have required the Part 18 on the basis that he didn't have the questions in front of him, then of course that means that his judgment is right and Mr. Justice Sweeting's judgment is wrong. That's point one. Point two is what I'm terming his substantive reason. His substantive reason is because there is this additional threshold test, a positive case on evidence. That's what the two limbs of why he refuses the Part 18 request. But it is worth noting. So at 44 and 45 of Judge Rowley's decision, and also paragraph 64 as well, which I'll come to, the judge says that Mr. Carlyle, the advocate before him, says one was to point out the dispute regarding the cash account would still be live, even if the Part 18 request was not answered. As such, it was inappropriate to dismiss the application when the substance of it would rear its head later anyway. And the judge says at 45, that does not seem to me to be a matter of any great weight. If there remains no evidence regarding commissions at the time of the cash account is determined, it is unlikely to detain the court for long. If there is evidence, then there will be an appropriate opportunity to consider it at the determination of the cash account. The judge specifically accepts that that it is in dispute and that he will determine it at the end. He goes further, paragraph 64, which is on large page number 216. What the judge says there is, therefore, whilst I'm not going to make the order the claimant seeks in this respect, I'm also not going to make any order for costs in the defendant's favour for declining to assist. Furthermore, if the claimant is ultimately successful in respect of the apparent dispute in relation to the cash account, I will entertain a submission that the costs of the correspondence, etc., are recoverable, notwithstanding that they have not been allowed by the order of this application.
Well, let us suppose, for argument's sake, that we accept Miss Bedford's submission that Section 70 assessment is not the appropriate vehicle for any dispute about the cash account.
Yes.
And let us suppose that we accept your submission that we should decide this appeal on the narrow basis that there is no threshold requirement applicable to a Part 18 request, such as evidence or even a positive case.
Yes.
What then is the position?
Well, the position then is that the appeal is dismissed, and this court may wish to make obiter comments about cash accounts and disputes. However, in my submission, that would be inappropriate because this court is not seized of those issues. But
I've a real problem with this.
yes,
There are grounds for appeal
yes,
which do raise this issue.
yes,
Which permission has been given?
And
Yes.
so when you say this appeal, the points are definitely, this appeal is on those points. Now you may object to that, or they're new points. That might be a ground of objection, but that is the basis of the appeal. Did you put in a Rule 19 objection?
no. But my lord, it's not.
So these grounds of appeal were drafted over a year ago.
Yes.
You say they raise new grounds, new points that were not before the judge, but there's no reason why a party can't take new points of law which weren't before the judge below, and we can give permission for that to be done. And when we say to you, well, what is the prejudice? Why shouldn't, if we're all here arguing over very small sums of money on a second appeal, then plainly, if there are points of law to be taken, then prima facie we would look at them. What is the prejudice to your client through now having those points of law determined?
Well, the prejudice is that as I say, if one takes the entire history of these proceedings, if I'm right, then this appeal should fail because the judge below was correct.
Why is it in anyone's interests, including your clients, that this case should continue on what may be a entirely false legal basis? Because this court has declined to decide the real jurisdictional question which was raised before it a year ago and for which it gave permission. And why would we possibly do that?
The question then is what is this court? What is the practical purpose of this court?
Points of law have been raised
yes.
saying Mr. Justice Sweeting's decision was wrong.
Yes.
Because of these points of law.
None.
And and for which permission has been given. Why should we not determine those points of law unless we can be shown that because, for instance, your client is prejudiced by that, we shouldn't?
Seems to me that the prejudice you're really complaining about, although you haven't articulated it yet, is that if there was no jurisdiction and we overturned Mr. Justice Sweeting, then you don't get your Part 18 request, which is what the judge gave you. That's the prejudice that you're complaining about, surely.
No, well, there are additional prejudice.
Yeah, but is that or is that not really the nub of the prejudice that you say you're suffering? If we overturn Mr. Justice Sweeting, you don't get your Part 18 request.
It's not just that. If this court overturns Mr. Justice Sweeting on the basis of different arguments that were not before him, then we have lost this appeal. And we have not only lost this appeal, but we were wrong to take the first appeal.
Well, the first appeal, while we're on the subject of the first appeal, I've reminded myself of what your grounds of appeal were. And if one looks at page 78, under tab 7.
Is this the core buzzer?
This is in the core.
Yes, thank you.
Tab 7, page 78, in respect of replies to Part 18 requests, 3.2, halfway down the page.
Yes.
Just waiting for my lord to find it. The Costs Judge was bound by the decision in Edwards and Slater-Gordon.
Yes.
Right, well, if we decide that Edwards and Slater-Gordon was wrongly decided, surely that's deciding an issue that you yourself raised in the appeal.
Well, my lady, I would... That if one looks at that in context, Edwards and Slater and Gordon found that the only threshold tests were the threshold tests as in Part 18. Judge Rowley found that there was an additional threshold test. What occurs in terms of the chronology of this is that Edwards and Slater and Gordon is handed down. That's a decision from Judge Rowley that's overturned. Then Judge Rowley gives judgment in the Brown and JMW case where the judge distinguishes Edwards and Slater and Gordon, and you can see I've taken your ladyship, your lordships to that. That's big number 212 at 40. He distinguishes Edwards because of the fact that in Edwards there was some evidence of secret commissions.
Yeah, that all well and good, Mr. Dunn, but just look at 3.2.1, please. The judge was bound, Costs Judge was bound by the decision in Edwards and Slater and Gordon, in which the High Court found that whereas here there was in the course of proceedings for assessment under the Solicitors Act a dispute over items in the cash account. That dispute must be resolved. why does that not fairly and squarely raise an issue as to whether there is, in fact, in the course of proceedings for assessment under the Solicitors Act 1974, a dispute over items in the cash account?
Because, my lady, Judge Rowley's decision was that there was a dispute in the cash in respect of the cash account. There was no suggestion that it wasn't part of these proceedings, but Judge Rowley found that the Part 18 should not be answered because of the additional threshold test. That's the only reason he gave. So that where here the appellant at that stage is essentially saying you're bound by the decision in Edwards and Slater and Gordon. The crux of that point is about the additional threshold test. Because Edwards and Slater and Gordon, the ATE company was in administration, and so when the client asked questions of the administrator, they returned with some answers.
Yeah.
So there was prima facie at least some evidence. What Judge Rowley goes on in Brown and JMW to say is that that's an unusual case because you've got some evidence, but going forward, Part 18, you have to have this additional test.
Look, I think we've probably pushed this point as far as it will go, Mr. Dunn. We certainly have your point.
Yes, I'm grateful.
What was in issue in front of the Costs Judge and Miss Justice Sweeting was the threshold.
Yes.
That nothing else was in issue, that it was accepted that if there were a dispute about the cash account, it would have to be resolved sooner or later in the course of the assessment, and that the solicitors now should not be entitled to take new points, even though they are in the grounds of appeal and even though permission to appeal has been granted on those grounds without any objection at the time from your clients.
Yes, I'm grateful, my lord, but I would finally just simply say that it would be to really reverse the burden somewhat to say that a party's failure to put in a respondent's notice initially and then to do nothing in respect of the first appeal, somehow the burden shifts to the respondent. The respondent is defending these two judgments, and that is what the respondent intends to do. So, I'm sorry, my lord.
I just have one more point on it.
Of course.
Your skeleton argument
Yes.
responds to grounds 5, 6 and 7
Yes.
and makes no objection on the basis that they're not open to...
No, there is an objection, and my learned friend rightly and fairly said at the outset there was an objection to these points being raised.
Where do I see that?
I think there is an objection somewhere to some of the points.
Yes, there was.
That's accepted, then, don't worry.
Yes, thank you. No, as I say, my learned friend very, very fairly accepted. Moving on to the substance, I'm sure the court will be pleased to hear. I appreciate the time. I presume the court wishes me to start, but if and continue after the lunch adjournment, or does the court wish me to begin my submissions?
I thought so.
Yes, I'm in your...
That's convenient.
No, of course. I'm in your lordship's hands and your ladyship's hands. So, in terms of the submissions that we will make, we'll provide a very brief overview and introduction, really, as to the issues underlying this dispute. I've taken the court through both the judgments, so I don't intend to do that in terms of Judge Rowley's. I may very quickly go through Mr. Justice Sweeting's judgment. Then set out what the Part 18 request was seeking, and also deal with what a cash account is and what it requires. So to answer some of my learned friend's points from this morning. Then deal with the correct threshold test as it pertains to Part 18, that's grounds 3 and 4. And then I can deal with whether the cash account was in dispute in the assessment proceedings. The question of the admission of the Part 18 requests, considering that they weren't before the judge, and also the Gibraltar Company point, which I know is a very minor point in this case, but is still live as I understand it, will be dealt with by Ms. Gopal for the respondent.
I thought you said it was academic, didn't you, in your assessment?
It's a
Because
point.
you've got the information.
Yes, but it isn't academic in the sense that it is not. It's still a point that is being run against me on appeal, and it's an important point, not potentially academic now, but it is an important point in terms of when a court should require solicitors to provide information to their clients or former clients in respect of that. My learned junior will deal with that point. So we say that in overview, the arguments being put by the appellant are unattractive. And they're unattractive because where a solicitor recommends and then purchases ATE insurance for a client, they do so as the client's agent. That is not in dispute. That's essentially what the case of Herbert and H.H. Law, which the court was taken to this morning, says. And that was accepted before Mr. Justice Sweeting. So the insurance is in the client's name. It's recommended that he purchase it. It's purchased on his behalf by the solicitor. And it is taken out of the damages that he receives ultimately. So he pays for it. Now, prior to Herbert and H.H. Law, ATE policies were included within bills of costs. And the learned Costs Judge Whalan, I'm not going to give evidence on that, but I defer to Judge Whalan's experience in this. Herbert altered that position because what the Herbert case said, and the Master of the Rolls said in that case, was that they were client disbursements rather than solicitor disbursements. So they're still a disbursement, but they're not a solicitor's disbursement, and only a solicitor's disbursement is required to go within the bill of costs. There is no dispute, and I should set this out at the start, there's no dispute on this side that the ATE premium does not appear in the bill of costs. I accept that. That has to be the result of the finding in Herbert that it is a it's purchased as agent on the client's behalf. I also, and I'll come to this later, but I also accept that it can't be assessed within the proceedings, because the assessment is the mechanism by which the court determines what is payable in respect of the bill. No dispute about that. Now, there will no doubt be submissions that I make, which are submissions on fairly dry pieces of law and interpretation of what a cash account is and what proceedings are. But just standing back, I submit, or we submit, that outside of this room, if anyone here asked a reasonable person whether someone who has had an agent purchase an insurance policy for them, and if that person then asked simple questions of the person who purchased that insurance policy, the idea that they would simply refuse to answer those questions would be both surprising and troubling. Just put it in another context away from solicitors. If I use a broker to purchase my road traffic insurance and I ask the broker a question, such as has been asked here, I would not expect the broker to say, "I'm not telling you," or "I'm not telling you, you're going to have to start Part 7 proceedings and you'll have to go through the court system." It is not attractive in my submission for solicitors essentially to hide behind, or to try and hide behind, Section 70, which is a part of an act which is designed to protect consumers of legal services, and say, yes, we did purchase this on your behalf as an agent, but we're not telling you anything about it. and you have to go elsewhere. So you'll have to have this Section 70 assessment, and because we won't tell you anything about it, you'll have to go to Part 7 proceedings
Or Part 8.
or Part 8, but those
That would be the position in relation to the broker, because there is no Section 70 in relation to the broker.
No.
So they're not hiding behind Section 70. What they are saying is Section 70 doesn't change the position it would be with any other
Exactly.
fiduciary who may have taken a secret commission.
but the fiduciary, yes, sorry, my lord. But the fiduciary's position is that they would have to account
Yes.
if they took a secret commission.
It's totally unattractive. Speaking of myself, I don't find it in the least bit difficult to accept the proposition that it is highly unattractive behaviour for a fiduciary, when asked a question, to say, I'm not going to tell you.
Yes.
But that begs the question of how you get the information out of him. And as my lord says, if the fiduciary is anybody other than a solicitor, there's a particular procedure that you go through in order to get the information out of him. And the question really is whether that procedure can be circumvented, or I don't use that pejoratively,
No.
whether you don't use that procedure, but you can find a shortcut to
Yes.
doing it within the cost regime.
Mm.
And if, as a matter of appropriate interpretation of the statute and the rules, you can't use the Section 70 procedure, then I'm afraid the concomitant is that you have to go against them by some other means.
Yes, and I fully accept your ladyship's point. My overarching submission is that standing back and considering the overriding objective, and it's important to note that Section 67, which we'll come to, applies to all Solicitors Act assessments under Part 3 of the Act. So Section 67 applies to all of these assessments. The overriding objective requires the parties to do two things, amongst other things, but two important things in this context. The first is to avoid expense and disproportionate costs. And the second is to ensure that the parties are on an equal footing. Now, the interpretation that the solicitors are seeking to put forward is that when interpreting the Solicitors Act, Cash Account and Section 67, one should interpret that solely and very strictly in respect of what payments on account have been made, and that's it. That's all that should be dealt with when the cash account's determined. My submission is, if one looks at the point of the Solicitors Act, the purpose of the Solicitors Act, and that's the point that the Supreme Court made in Menzies, the purpose of the Solicitors Act, and then also looks at Section 67, which applies to assessments under the Act, and considers the overriding objective, how is it possibly right that an interpretation of the rules, which requires in modest cases such as this, not just a Solicitors Act assessment in respect of the success fee, but then separate proceedings in respect of £50 or £25 in respect of a secret commission, when the alternative is that the solicitors, as fiduciaries, should answer a Part 18 request, and once they've answered it, and it would probably take no more than 15-20 minutes for them to answer this. This is not difficult, this is not information, it's not they don't have to trawl through thousands of documents. They know the answers to what's being asked. How is it possibly right that rather than spend the 15 minutes and enlighten the client upon who they purchased this premium for as agent, they say, no, we're not going to do that. We're going to have this assessment and you're going to have to go elsewhere.
Would
And
you like to develop the answer to that question at 2 o'clock?
of course, thank you.
Are you able